You're listening to Tech Policy Grind, a show about tech law and policy and the stories of the folks making their way into the field. My name is Emory, and from the bottom of my heart, I want to thank you for joining us on this awesome adventure we've been on since launching the show last year. Our release schedule hasn't always been the tightest, and our audio quality hasn't always been the most polished, but you have stuck with us as we've covered everything from privacy to artificial intelligence to copyright to privacy. Okay, there has been a lot of privacy talk, but it has been a big year for privacy. Facebook and Cambridge Analytica, the general data protection regulations, more Facebook. Unfortunately, Pinnell couldn't join us today, but Joe and I are closing out the first season of Tech Policy Grind, with a bit of a meandering deep dive into the new California Consumer Protection Act of 2018, YouTube's COPPA problems, and a bit of a retrospective as we look back on almost a year of awesome conversations and forward to the next. So, we're going to be going on a bit of a hiatus for the next few months for the summer, but don't let that stop you from reaching out to us on Twitter at Tech Policy Grind and letting us know what you think of the show. We'd really love to hear your thoughts and especially any ideas for Season 2. With that, I'll sign off for the summer and bid you all adieu, and best of luck staying cool. Enjoy this wonky privacy talk with Joe Jerome and myself, Emory Roane, on Tech Policy Grind. So, yeah, Joe, it's been, God, when did we first start doing the show? Has it been, I think we tried to have our first recording back in the 1st of October or something. Does that sound about right to you?
That does sound about right. It's fast. I was trying to think. We initially were having conversations to do this in August with the hopes that we would get something started in a month, and then things kept getting delayed and delayed and delayed.
What, our eyes were bigger than our schedules, I guess, or our free time?
Right. And then also just trying to dream up topics. It's sort of, I think it's the toughest thing about doing a tech podcast is you either react to the news of the moment, which is constantly changing, but then that makes a huge time crunch to put things out while they're relevant, or you try and just find themes or interested people willing to talk about anything, but it can be pretty far outside your wheelhouse, so then you have to educate yourself on stuff when you are busy doing your own work.
Yeah, it has been a humbling experience. I think that when you said that, though, it totally just brought me right back to like professional world life, and that's just the struggle with working in privacy today. Is I feel like you're constantly either reacting to things that are like all the travesties that are happening day in and day out, or you're trying to look ahead, and then you are missing the things that are happening day in, day out because it's just constant.
It's frankly exhausting.
Oh
so I know you and I are both like privacy people, and I think the lesson I take away from the past 6 months is that there's just so much going on in privacy and data protection, but then talking to some of our guests and also just keeping tabs on the news, there's so much other stuff going on that may have a bigger, frankly, impact on society and my life, that it gets hard to then shift back into, I'm gonna read and critique a privacy policy today.
Yeah, and yet, the more I get into privacy, the more you feel like all those other major issues are also touched by the privacy problem. But maybe that's just because I'm too much in the weeds, and
I think we're all too much in the weeds. We hosted, and I think we're going to be talking about this later before we wrap up. We hosted a call about the California privacy law, AB 375, this week, and there were some other people on the call who afterwards were like, I paid attention to the first half hour, and then frankly I didn't have a clue what any of you were talking about. And I was just sort of, and I took that partially as, well, wow, should I be insulted by that? But no, I'm sort of glad that our call got so in the weeds and so technical that it was useful to just the small group of people who are working on this.
Look, it's so much better to at least be so technical that you're in the weeds rather than so, sausage making or political or all the other things that can derail a otherwise productive conference call.
So, all right. So I think we're here to wrap up a season of Tech Policy Grind. You have detailed or long history working on podcasts. What was your takeaway from our 14 or so episodes of this compared to your time on This Week in Law?
Well, I mean, best decision of the year was absolutely doing this not live. I love the ability to edit podcasts. All my dear listeners, you will never know any of the stupid things I say because I edit this show and I make sure I sound smart as possible. No, I mean, it was, I got to say, actually, this was a show that, I think, flew by the seat of our pants as far as planning and executing and then recording. But I think that the format has really come into its own. I'd love to continue doing this next year or after the summer. But, I think that there is a place for this show. And I think that what this show is doing is rather unique. Bringing on early career professionals to talk about the way they're getting into the field. And interspersing that with sort of in the weedsy tech policy law discussions. I've had an absolute blast. But definitely we've learned some lessons that hopefully we will take into next year. As you are probably aware, dear listeners, this episode has missed the deadline a few times on our scheduled release date. We're going to try to be stricter about that next year. But as Joe was alluding to earlier, this past month has just been absolutely insane for privacy and tech law in general, and Pinal has been slammed as well. What about you, Joe? Any lessons that you've learned from the past months?
I think it's sort of the formalities of doing panels in DC where you try and let people talk, but I actually think the best episodes that we did were I think conversations, and that's actually surprisingly hard to do in a podcast form. I mean, some people don't have video enabled, so you can't read people's eyes, you can't read the room. You don't want to interrupt people who are giving really interesting thoughts, but at the same time they're engaging in quasi monologues. So that's been interesting. I mean, in terms of just skill set development, it's been, I think, good for me to learn a little bit of how to interrupt people. Hopefully not too much. Hopefully not where inappropriate. But it's been a lot of fun, and I agree with you that there's room for tech people to be sharing their stories. I mean, there's endless numbers of shows out there or podcasts that will tell you about more about blockchain or IoT. But it's really rare to understand. And frankly, I think what's really interesting about the Internet Law and Policy Foundry, certainly the guests we've had, but I know there's other fellows out there, have really interesting backgrounds. It's been nice that not everybody on the show has been a lawyer. Perhaps too many of them have been, but that's just because lawyers are comfortable ranting and raving more often than other folks.
A lawyer comfortable talking for hours?
Yeah, right.
What? Shock. The other thing to keep in mind is I think you hit the nail on the head that it is such a great opportunity to expand your skill set. For any listeners that have any kind of inclination to be speaking in public, or really I think it benefits, honestly, any profession that you're in, but the ability to just speak comfortably and speak competently about a subject is invaluable. And if you want really great practice or a really uncomfortable view into all of your idiosyncrasies and speech imperfections, record and edit a podcast with yourself in it.
And we have to listen to this stuff.
Oh yeah, several times.
You've done the lion's share of editing, but I've edited a few myself, and it's frankly fantastic that you can edit yourself a little bit to sound better, get rid of the totally obvious ums and uhs and likes. But on the other hand, you really do just sort of listen and learn a lot about how you speak and ask questions. I mean, frankly, I think we were always sort of challenged by this, where we'd come up with, well, let's ask some simple questions to folks. But if the podcast or the conversation's going really well, you're not just asking questions. You're sort of framing what you're interested in saying. And I've always sort of had a hard time doing that. I realize after saying a bunch of words that I haven't really said anything at all. And what's my question? It's nice to have that laid bare in a podcast for all eternity.
Oh, absolutely. The sheer number of ums, uhs, and likes has definitely gone down. I'll say that absolutely. As recording, or editing our recordings, the idiosyncrasies and the speech imperfections that we were talking about, that you get better at them when you have to hear how many ums and uhs you say every time. It creates a little monkey on your shoulder that's just don't do that. So
right, and you hear yourself saying it, which is terrible.
It's only slightly better than seeing yourself saying it. Only slightly better. But yeah, it's an awful experience. But I recommend everyone do it at least once. It's
right, and that's our sales pitch, that you all should join us next season. We'll try and reach out and be more proactive about that.
Yeah, we really would love to have more guests next show. We're going to try to, or next season, I think we're going to try to expand outside of the Foundry. So we've had a couple people that have reached out this year and have asked to come on the show as interview guests that haven't quite worked out just because of timing, but we're going to work super hard next year and really try to open up the ranks of guests to more folks, and hopefully more folks that you'll find interesting. But how about we talk about what's changed in the past 6 months? I mean, you're still at CDT. I think that I had officially started an internship at Privacy Rights Clearinghouse on our first episode, or maybe I hadn't even done that. I think that I remember we were riffing about me getting my bar results back, so it feels like an eternity ago before the great joblessness period. But
do you find yourself now in a position of giving people unsolicited bar examination advice? I mean, we're in another cycle. People are spending their summer stressing out for the bar.
The thing about the bar, I mean, first of all, my wife is taking the bar right now, so yes, I'm getting tons of unsolicited bar advice. It sucks.
No, okay, I draw the line. Everyone thinks I'm insane. I loved studying for the bar. I loved taking the bar.
I mean, I feel like I don't even need to respond to that, Joe. You opened it up. Everyone says you're insane because that is insane. The bar is a terrible, hazing, miserable process. Change my view.
But that's a lot of life.
Yeah.
Look, here's my advice to any, and look, it's obviously a serious exam. People put a lot of their, time, money, energy, self-worth into it. But studying for the bar exam, you should treat that like a job. 8 hours a day, and then you go home and find your inner calm. Instead, you have people just, I think, pulling their hair out over things they can't control. You also don't need to know everything. You just need to know some of something.
It is a test of minimum competence was my
there you go.
Like my ringing or my mantra the whole time I was preparing. Minimum competence.
And I always found, certainly while taking the exam and for the week afterwards, it was the one time in my life where I actually felt like I had a little bit of grasp of what it means to be a lawyer and all the different elements of being a lawyer.
Yeah, but I mean, that being said, that's what's so frustrating about it is that I know, even at that point, and I know exactly the point you're talking about, where like you're just living, breathing MBEs, and you could write essays in your sleep, and you feel like you've got a grasp on the material, but then you stop and you think about, wait a minute. The kind of law that I'm interested in is not at all is not at all tested here. And in fact, this whole period I've been, cramming my brain with torts and crim law. I've let all my privacy knowledge sort of dribble out of my ear canal, and I'm going to have to reacquaint myself with, everything that's happening in the world of privacy and copyright next, in a few months.
And for our non-legal listeners, I think it's fascinating how little technology infuses into what's taught in the law and actually given on the bar exam. Yeah. Which at least shifts us, I think, a little bit back onto topic.
Do we want to talk about AB 375 at this point? I feel like it's probably a good time to segue
it's my entire life.
Yeah, into some privacy discussions. I don't know how involved you have been in AB 375, the California Consumer Privacy Act of 2018, also at one point called the Common Sense Privacy Act of 2018. But it's been, as you can imagine, at Privacy Rights Clearinghouse here in Southern California, basically top of the list of just, constant
should we tell
work.
Should we tell people what this thing is? And you should feel I'll offer to do it, and you feel free to interrupt me if I'm not giving an accurate perspective or if I'm getting too political.
All right, sure, go ahead.
So the way I've been trying to describe it is AB 375, the California Consumer Privacy Act of 2018, was a last-minute legislative frankly, I've never seen legislation passed so quickly. It was revealed to the public on a Friday and passed the next Thursday, so under a week. It was a legislative response to the similarly titled California Consumer Privacy Act of 2018, which was a ballot initiative that would
and therein lies all the worms.
Yes. This ballot initiative was put forward by Alistair McTaggart, who is a San Francisco real estate developer who had a conversation with a Google engineer and became really concerned about his privacy. And so he threw a bunch of money into this ballot initiative. Frankly, if people we might want to include this in the show notes, but Kashmir Hill on Gizmodo did a really good deep dive into the politics and history of this thing. But I don't know where you are, Emory, but this ballot initiative first came frankly, got on our radar when we started the show. We first saw it last fall.
Yeah, it really has been winding around for that long. It feels like on the one hand, this AB 375 came out of nowhere, but for the folks that have been up on this ballot initiative, it's just been like an undying, endless source of meetings and discussions.
Totally agreed. And I think a lot of people, because it was a ballot initiative, and ballot initiatives in California are, I think, worth investigating by their own.
Let's rewind. Let's pause here and talk about the ballot initiative, because I think that's also sort of a bizarre, legislative process that not many people are aware of. So California, I think that a lot of the opposition to AB 375 or the anger about it for some folks just is really directed at the ballot initiative process. The fact is that California has this kind of bizarre, maybe arguably undemocratic, arguably oligarchical legislative process where essentially anyone, the way it's framed is that any Californian can get something put on the ballot in November if they write a piece of legislation and get enough signatures on a petition, and that will then go directly to the ballot and be voted on. I think the number of signatures right now is maybe 300,000 or so. But regardless of the specifics, Alistair McTaggart was able to secure the requisite number of signatures on this piece of ballot initiative legislation that he wrote, the California Consumer Privacy Act, and it was going to be on the ballot in November. The AB 375 was sort of a last-minute legislative compromise, I guess you could call it.
So what I think is fascinating here is that, and I think privacy advocates, including myself, are a little bit to blame. No one, I think, took this ballot initiative seriously until Facebook and the giant hubbub over Cambridge Analytica. That really supercharged what this thing was. And
I mean, it's the perfect storm, right? It's that, but it's also GDPR. I don't think you can ignore that.
We cannot forget the general data protection regulation in this. But I think what's fascinating is at the end of the day, so, I think usually the way legislative sausage is made is you obviously have legislators. On one hand, you also have, you have consumer groups, civil society, privacy advocates pushing for their proposal, and then industry and their trade associations trying to do something else. Here, you really had Alistair McTaggart was just this guy who had a mission, and the only negotiations were with him. So,
well, why is that? All right, I didn't do a great job of basically explaining why that occurs, though. So with the ballot initiative process, once something is put on the ballot, once you reach the number of signatures required, it goes on the ballot. But here's the part where California kind of creates a bad situation, arguably, and that is that after a ballot initiative gets on the ballot or reaches the number of signatures, the only way it can be amended or pulled is if the person that the proponent, the person that submitted it, or what is the right word? Not submit, but I guess the person that submitted the ballot initiative, the proponent is allowed to pull the ballot initiative, and only that person. And so you can see the situation where if you've got enough money to make enough public waves, you can basically get enough signatures on a ballot initiative, and then essentially have all the leverage, where the only way that ballot initiative can get pulled is if you personally decide to pull it. Now, in the deadline for the decision to either pull the ballot initiative or leave it on the ballot for November was June 28th.
A Thursday.
This past Thursday. And so that created the situation where, in a lot of ways, this ballot initiative was more radical than, or at least more restrictive on industry than what we eventually saw in AB 375. And so rather than okay, you're right.
So
I don't want to oversimplify this, but
it's interesting. The ballot initiative, for people who, is really lengthy, very detailed, but it functionally operates as a right to know and then a right to say no about, quote, selling of personal information. That's all it does. The actual final law has some GDPR type components, but I think what we're also missing is this ballot initiative had two other elements in it that I think scared both companies and, frankly, the California State House.
Private right of action.
It had a private right of action, and beyond that, not only is it hard to amend the initiative once it gets certified. The actual initiative basically would have locked that into law. It had a provision, and I frankly, Emory, you need to explain how California does this, where any further amendment by legislators was basically a supermajority that had to be consistent with the intent of the initiative.
Yeah, that's so part of the ballot initiative process. It's just so bizarre. Like, the ballot initiative is, and this also gets like way above my head, frankly. But yeah, the ballot initiative is really, really difficult to amend. And so that was one of the reasons why a whole host of advocacy organizations weren't throwing their support behind it.
Anyway, everybody came to a deal and somehow passed a law in under a week that I think is fundamentally reshapes how we discuss consumer privacy in the United States.
Yeah, absolutely. I think I don't see how any reading of that couldn't come to that same conclusion. It essentially, what the ballot initiative, or what AB 375 does, is that it first of all, it doesn't cover, I think it's important to remember that it's not affecting every single California company that holds personal information of consumers. So it's not, a lot of people are saying this is California's GDPR, and it's really not California's GDPR.
No,
it doesn't go nearly as far as the GDPR, and it really shouldn't be framed that way. Because it doesn't affect every single business. It only affects businesses that receive that have more than 25 million gross revenue per year, that sell the personal information of more than 50,000 consumers per year, or that derive more than 50% of their yearly income through, or gross revenue through, the sale of personal information. But for those businesses that are covered, a consumer has a right to know what information that business has collected about them. You're able to request that information be deleted or provided to you in a way that lets you take it to another service. You have the right to know. You're able to request that the business tell you what categories of third parties your information is being sold to. And you're able to opt out of the sale of your information to third parties. And there is a requirement on businesses to place a button on their homepage that says, "Do not sell my personal information," that will opt you out of it. And the bill allows for additional third parties to sort of opt you out of that, or facilitate that opt-out process. So I think you can expect to see some cottage industries pop up around sort of making that process easier. And then some of the more controversial sides of it is that the private right of action that was included in the ballot initiative is extremely weakened in AB 375, where in the ballot initiative, essentially any violation of any part of the act gave rise to a private right of action that an individual consumer could sue on. Under AB 375, you only have a private right of action in the case of security breaches. So when a business has experienced a data breach and your information has been exposed and then disclosed or transmitted or sent to a third party, and you can show that that entity did not implement reasonable security measures to secure your data.
Well,
yeah.
And okay, that's that. You lost me. That's a giant laundry list of
stuff.
Yeah,
exactly.
In general,
the private right of action is generally just totally gutted. I think
right.
It's fair to say.
And we've missed episodes where, we've had episodes on this very program, right, where we've discussed what constitutes reasonable data security.
Yeah, exactly.
And
we've tried to discuss it, and I think
yes, and since those episodes, there's been decisions that have come down in the LabMD case that have, I think, narrowed what reasonable security even really means. So functionally, I don't know how, so Emory, I guess I'd be interested to know what your take is. I imagine you think that on the whole, this is an improvement, but even though there is a limited private right of action, I think companies will tell you that you're still going to have those evil plaintiffs firms filing actions all over the place, and they're still going to. Companies are going to end up having to burn time and money on, discovery requests to determine what the hell is a reasonable data practice.
I mean, I for one, am completely shocked and surprised that any business would, use the excuse that the regulation is going to cause more hardship. I think that's a really original and totally unique. I've never heard that before, but I think that net positive. I think this moves the needle forward. I think that this, at the end of the day, it confers rights to Californians that they simply did not have before. This is a compromise that is, I think, moving the needle forward and conferring rights that we don't have, and is advancing the privacy discussion, but it's definitely not perfect. The process is super weird and not awesome. And there are ambiguities in the text. I don't think that the act as written is the most clearly written language of any legislation I've ever seen.
No.
And, it doesn't take into effect until 2020. And so the next 2 years are going to be a real battleground at the Attorney General between industry and advocacy organizations trying to make sure that the regulations that come out are actually strong and that the protections in the act aren't further weakened.
Right.
But it's exciting, right? Like it or not, the complaint has been levied against this over and over again that this is undemocratic and it's ridiculous that California passed this in a week, and this is the wrong way of advancing privacy in the country. And it's like, well,
what's the right way?
Yeah, first of all, what's the right way? First of all, what's the friggin' right way? Because if we were looking at our cards on the table, legislative strategy at Privacy Rights Clearinghouse this year, we were going to consider it a victory if we would be able to expand the data breach notification statute to include paper records. Like, that was going to be our, pop open the champagne. We've got paper records, including the data breach statute. So first of all, that,
Right.
What is the right way?
I'm very sympathetic. So I'm very sympathetic to industry's notion that this AB 375 is a mess. It is. I also wanted to, this is a larger conversation, but I would throw to you the notion that it's going to give Californians more rights. That's technically true. The question always ends up being who's going to exercise those rights.
Yeah.
Bigger picture.
Yeah, totally.
I think privacy needs to shift from, you can get information dumps, to actually sort of putting limits and prohibitions on companies.
Yeah. We need to follow the EU model. We need to reframe personal information around personal data, It shouldn't be personally identifiable information. It should be personal data.
So what I think, and again, this goes back to some of you had industry saying that the ballot initiative was anti-democratic, but I think industry in general, certainly not all, but a number have been just they've put up opposition to privacy legislation. And I keep telling these folks that you keep doing that, you're losing the war. The rest of the world is just sort of going in a different way. And the United States has, so I always think I'm coming back, I'm sort of rambling here, but I don't think AB 375 should be considered anything close to the GDPR. It doesn't even meet even in the things that it's taking from the GDPR, it doesn't even get you anywhere close to that type of stuff. But I think it sends a powerful message that this approach that the U.S. has had, where we're just not going to do anything, isn't going to work. Now, totally. I'm also cognizant of the fact that we still have sectoral laws, and I don't know how you harmonize all of this stuff. But I guess I think this is a message, no matter what, that the constant industry refrain that any type of regulation is going to harm innovation is tired. Let's move past that.
Totally. This is totally anecdotal and also kind of rambling, but, we were at a an IAPP KnowledgeNet meeting recently, and talking to, like, the IAPP, like, the folks on the privacy compliance side of things, not the advocacy side, but, like, the folks that are in privacy compliance, the ones that we spoke with about the, ballot initiative or AB 375 are all pretty, like, yeah, I mean, it basically just follows FIPS, and it's not, it's not revolutionary, and especially if you're already following GDPR, it's not going to cause the sky to fall. And so, yeah, I mean, it is always the argument is always that any regulation is too much regulation. But I really think that if you actually look at what this act does, I think 99% of consumers would agree, oh, that sounds actually kind of reasonable. Like, I should be able to know what information a business has collected about me. I probably should be able to opt out of the sale of that information, right? And yeah. And,
certainly I don't know if opt out of my sale of personal information button on the Google homepage makes a whole lot of difference. But, I think this does put new obligations on companies. Well, let's go back to Equifax or the data brokers out there that we have just refused as a country to actually grapple with.
Yeah, totally.
There is, I don't want to, it's certainly not a black market data market, but there is sort of this universe of data sales and transfers that are going out there that people just don't understand.
It's not a black market, but it is totally intentionally, completely opaque.
Yes.
I mean, do we want to, I guess there's, I am singing this act's praises, but I think that there is a really great discussion to be had around the shortcomings of the act. It feels, first of all, super weird and uncomfortable and like surprising to be, coming down on this act so diametrically opposed to the viewpoints of other advocacy organizations that I really respect, like the ACLU. So, listeners, the ACLU gave a really stinging lambasting of the act as not going nearly far enough in their public statement. One of the things that ACLU pointed out, I mean, first of all, they railed against the limited private right of action, which I think is totally justified. We would really like to see that expanded. Whether or not that would have been politically feasible is another story. But they also, they and other organizations are concerned about the idea that this act codifies a pay-for-privacy scheme.
Yes, that's something we hadn't discussed.
Yeah, so one of the, definitely the most controversial element of the entire act is that it includes language that the intent is to prohibit a sort of pay-for-privacy scheme. And for listeners, our pay-for-privacy is the sort of dystopic scenario that I think that we're barreling towards, where privacy is essentially a commodity for the rich, and that you're just going to have an underclass of citizens that just do not have access to privacy because it's a paid-for element, and the free services are all privacy invasive. And so, I mean, first of all, obviously, anyone that's in the privacy advocacy world is super concerned about pay for privacy as a scenario, I think that everyone at Privacy Rights Clearinghouse thinks that this is probably inevitable if we don't have some sort of protections in place around it. And this act includes language that says that, a consumer has the right not to be discriminated against for exercising their privacy rights.
As the Senate Judiciary Committee, their report on the bill actually sort of suggests. So the bill is in tension with itself. It's simultaneously suggesting that you should non-discriminate, but then permits it in a variety of scenarios that are entirely unclear.
Yeah, so it is unclear. Well, the bill says that it prohibits it, but then it also acknowledges that I think, I mean, this is where I would really like to have an awesome constitutional law expert on here, but I mean, from my understanding is that a straight prohibition on any kind of price, quote unquote discrimination or like price differential around privacy, I think that would be unconstitutional, for preventing the ability of people to enter into contracts with each other. But I mean, regardless, whether or not it would be constitutionally or unconstitutional, I think is undeniably politically untenable that you could just have an act that straight up prohibits any kind of, contract where privacy is a component in the discussion around price. Because I'm a privacy advocate, I'm a privacy maximalist, but like there will be people that will want to make that exchange of, cheaper services that that they need for the exchange of their private information. That will be a rational decision that they will make, and we shouldn't be so paternalistic that we say that they're not allowed to do that.
I think we have to deal with larger ethical considerations. So if you talk to straight up consumer advocates or disability advocates, they'll say these types of things are totally good. If people can't get cheaper products, then what's the point of fighting over who controls data?
Yeah.
When at the bottom line, if you're under resourced or frankly poor, like you just need to eat. And I always come back to things like customer loyalty cards, grocery store loyalty cards. Yeah. People need to have cheap milk, and if we can't find a way to facilitate that, we have larger problems on our hands. That said, when you're at a grocery store signing up for a loyalty card, and if you think about how differential pricing works long term, you can imagine that raises lots of really problematic issues where certain people are being peddled certain products.
Totally.
And then of course the system currently works where that information, that program isn't being run by the grocery store, it's being run by some data conglomerate behind the scenes that nobody's ever heard of,
or Amazon if you shop at Whole Foods.
Or Amazon. And I guess large picture here, I think this entire issue, the initiative, this law, highlights how difficult it is to actually write privacy legislation.
Yeah.
We spend all of our times talking about high-level principles, best practices, codes of conduct, and then when it comes to the nuts and bolts of trying to write something, it gets really hard, or we default to some sort of adding additional, it's more transparency and opt-ins, opt-outs.
Yeah.
Because
if that's really as if, first of all, you have the choice in the matter, or that more transparency is going to make that choice suddenly a real choice.
But I think we do that because it's very hard to deal with and confront these types of issues. And I take your point that maybe this really can only be settled through litigation. From our perspective, I'm saying our as if I'm representing the Center for Democracy and Technology. Maybe this is my personal perspective. But this sort of comes back to the need for, I think we hear over and over again from people inside industry, but also outside, that when it comes to technology and privacy and all of this stuff, you need both, I think, a degree of consistency, but also flexibility, and law has a hard time doing that. And I think long term, what this really calls for is, if not private rights of action, because then that makes us deal with figuring out what constitutes harm, but rulemaking authority.
At some point, we will really need to nail down what a harm is.
Well, you didn't want to talk about this on the show today, but I think there's an interesting path forward if you look at what the Supreme Court did in U.S. v. Carpenter, where you're starting to see a certainly majority of the court recognize there's something different about technology. And I'd also point everyone to Gorsuch's opinion, which, even though it's a dissent, is functionally a concurrence, where he's talking about property ownership in data, which I know tends to be a really contentious issue. But he's trying to, I think, sort of split the proverbial baby by saying that people can have ownership interests in things that are conveyed to other people. It's not all mine and all yours. It can be part mine and part yours. And I think that thinking really comes into play with data flows. Of course, that's just in the government context of surveillance and law enforcement. But when we act as if commercial privacy is completely divorced from that, we have our own problems. And then I sort of just point at the EU General Data Protection Regulation as a catch-all that gets everybody. Of course, it has its own problems.
Yeah. It has its own problems, but I don't think the sky is falling like so many people said it would.
Right. Well, I'd love your take on this. Companies are constantly. So I think where there's a really interesting point of contention here, and was in 2013 when the Federal Trade Commission changed the rules on the Children's Online Privacy Protection Act. This bill actually sort of extends some of that to kids age 16 or above.
Yeah, this does sort of have a weird COPPA element to it.
But COPPA's interesting because, if you're a company that deals with COPPA, you're good to go on GDPR. At least that's what I've heard. And, I would argue, I remember 5 years ago, companies saying, well, if these rules go into effect, it's going to be the end of children's entertainment online. And I don't think that's the case. I don't think the sky is falling there either.
No, I think that is it common sense, though, to has a complaint against Google's YouTube for COPPA violations. So, I mean, maybe it might be the case that children's entertainment is just on YouTube, at least, is existing in violation of COPPA. But yeah, I mean, I think that. Again,
we should have found somebody to come on and talk about that, because I thought that was it was a very interesting piece. It is an interesting piece of litigation. Because you don't. Well, I guess they file. It's interesting. People keep filing complaints around COPPA to the FTC. COPPA doesn't have a private right of action, but in California, you're certainly seeing litigation that tries to bootstrap violations of COPPA onto tort violations or California constitutional law violations. But what I think is interesting, I think I'm torn, because I read that and I sort of am convinced that there was a COPPA violation here, but at the same time, what do you want to do? Do you want to shut down these sort of family-friendly zones that Google was trying to curate on the grounds that they were trying to do some content moderation, but not some straight privacy moderation? I don't know how you resolve those tensions.
Yeah, I don't know either. That was my reading of it, was just I think that there is actually. I mean, my reading was I think that YouTube might have dropped the ball here with their COPPA compliance on YouTube.
But what do you want?
But yeah, it's. I mean, in order for them, essentially, the complaint, if I understand it correctly, and feel free to correct me on this one, Joe, is that look, Google or YouTube started this platform called YouTube Kids. And on YouTube Kids, they are serving only YouTube child content, like content designed for children, which means
in compliance with COPPA, which means that so whenever a child goes on there, they have to get permission from their parents, etc. There's a whole process for that, which means that though YouTube knows the difference between content that is directed towards children and content that is not directed towards children. And the problem is that children directed content is not only on YouTube Kids, but is also on YouTube proper, like YouTube default. Now, YouTube Kids requires users to actually sign into a Google account and a parent to, click yes. I am allowing my child to use this, and that's why they're compliant with COPPA. But we all know that YouTube proper doesn't actually require anyone to sign in at all. It just lets you watch videos that are on YouTube. So COPPA has an element where if you have actual knowledge that there is content that is directed towards children on your website and children are viewing your website, then you have to be in compliance with COPPA. You have to go through these steps. And because now the situation proves that Google knows that there is content directed towards children on regular YouTube, and they know based on their massive analytics on their website that a huge percentage of YouTube regular viewers are under 12 children viewing this content. And so for that reason, they have actual knowledge that minors are viewing this content on YouTube regular without going through the COPPA process. And so that sounds like a violation of COPPA to me. All right. I just want to say it's you described the situation far better than I did. Is that all off the top of your head?
Yeah,
that's very impressive. See, I've realized more and more that I just don't have the ability to articulately describe some of the stuff that I'm thinking in that way.
You're just bouncing from one topic to the next. I don't know how I remember. I mean, I think that I was.
That was very good. That was a very excellent articulation of the legal issues involved with COPPA, what YouTube is doing, and what the actual problem is.
Yeah, don't ask me to talk about Carpenter.
Yeah, right. So I feel like we need to have some sort of proper wrap-up, and it's unfortunate that Pinal isn't here to celebrate with us. But as we go dark for a period of time, what are your plans for the summer? Or frankly, what are your plans for the duration of your time as a Foundry Fellow?
Man, I don't know. I'm super excited about the onboarding of a new class of fellows. It's such a bizarre experience. I just want to give a little bit of recap of what my year has been like. When we started this show, I had just got my bar results back, but I was totally jobless, and had no idea what I was doing, and was just sort of throwing applications to the wind and doing this podcast in no small part because I was jobless and hoped that it would improve those possibilities. But in that time, I found a position at Privacy Rights Clearinghouse doing some contract work, and then I was brought on as policy counsel. And now I've got my own desk in this amazing office here, and I've got some interns from my school, from my alma mater. And, you know,
your own minions.
I know, I've got my own minions. It's very cool. And some of these kids are just super smart. And yeah, I would love to see them go through the application process and, you know, become Foundry Fellows as well. It's been, you know, hugely helpful to me. And yeah, that's something I'm really excited about. So hopefully come fall, there will be some more information about onboarding the next class of fellows. Other than that, man, I'd love to get back to DC to try to do another Foundry meetup. And yeah, my summer is hopefully just going to be playing a bunch of D&D.
Nice. Well, I guess I'll wrap up my thoughts by thanking you for sort of leading the charge on this. I've multiple times in my life tried and failed to start a podcast. I did a podcast series when I was at the American Constitution Society that just sort of sputtered by virtue of the fact that it had to be approved by so many people. Then I started doing, just for my own, again, try to improve public speaking. I would do like a weekly 15-minute privacy recap called Privacy State/State of Privacy, which I gave up on after about 2 months just because it's hard to do a podcast by yourself when you're actually having to do other work. That I mean, that's really just what it boils down to. It's really hard to do things by yourself. And so, you know, one of the things that I was really interested in with the Foundry was the ability to try and connect with other folks, but then also to use this selfishly to improve my speaking abilities, but also just to work on communicating with folks and getting out stories in a digital form. And as a big podcast aficionado in my personal life, I wanted to do something with the group. And thank you for your leadership on this.
And I guess I'll also say, it's totally been a team effort, man. It has been a lot of. It would not have been possible for me to do this by myself, and I wouldn't have wanted to. So,
so you say.
Yeah. Yeah, well, I want to put out a huge thank you to all of our listeners as well for sticking with us. Yep. I know that you know, our show is still very indie, so our listeners that we have, we hugely appreciate you. Yes, you listener, right now, you. Thanks, we appreciate it. If you guys have any criticism, any thoughts, any you know, if you like any of the discussion we had today and think that it should be the format for the show in the future, if you got any radical ideas about what we should change, you know, let us know. We're huge. You know, we really, really, really would love to hear from you.
We want criticism. Frankly, I would love for someone. There's been people who have surprised me that were listening that come up and said really enjoyed the show. But I would love to have a critic come on and just yell at us for half an hour.
Yeah, absolutely. We're lawyers.
It's a challenge. It's a gauntlet has been thrown.
This is what we do. You know, one of our favorite things is writing something and handing it to someone and having it handed back to us with red ink all over it. So
yes.
So yeah, if you've got some red ink to share, please let us know. Reach out to us on Twitter at Tech Policy Grind. I'm personally at Emory Roane. Joe, I think you're at Joe Jerome, right? Or
I am indeed.
And yeah, we'd love to hear from you. So with that, I think we're going to wrap up this kind of long, meandering discussion on privacy rights and Tech Policy Grind and California and everything that we've been up to, and say happy summer.
Stay cool, everybody.
Bye. This has been an episode of Tech Policy Grind, a podcast from the Internet Law and Policy Foundry. We're a collection of early career professionals paving the way in the tech policy world, and we really hope you enjoyed the show. If you like what you just heard, it would be a huge help and mean a lot to us if you could head over to iTunes and leave a rating and a review. If you don't have iTunes, maybe just share the show with a friend. You can follow us on Twitter at Tech Policy Grind and keep your ears peeled for new episodes twice a month on alternating Mondays. We want to thank Ali Sternberg for producing the intro and outro music for the show, and thank you all for listening. So, until next time, thanks.